Hello everyone, this is your host Urvashi Chauhan. Welcome back to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Let me start by informing you that a Delhi court has today extended the judicial custody of Chief Minister Arvind Kejriwal in the money laundering case connected to the alleged liquor policy scam till 3rd July. Vacation Judge Nyay Bindu of Rouse Avenue Courts extended Kejriwal's judicial remand after he was produced from the Tihar jail through virtual mode on the expiry of his judicial custody. The court also heard Kejriwal's regular bail plea. While Kejriwal's counsel completed the submissions, ED submissions were completed in part. Senior advocate Vikram Chaudhary, representing Kejriwal, informed the court of two Supreme Court orders, one granting interim bail and the other reserving judgment on its plea against the arrest. He mentioned that the Supreme Court allowed Kejriwal to apply for regular bail while the judgment is reserved. Chaudhary pointed out that Kejriwal had not been accused in the scheduled offence so far. He clarified that Kejriwal, as a constitutional functionary, was not seeking special treatment, but the chair ought to be respected. He questioned the timing of Kejriwal's arrest by ED, noting that it happened soon after the general elections were announced. He doubted the credibility of the evidence from witnesses who were pardoned and became approvers, specifically mentioning the name of Magunta Reddy, who is a member of the now ruling NDA alliance. Chaudhary also cited medical reasons for seeking bail. Additional Solicitor General S.V. Raju, representing ED, on the other hand, began by contending that the Supreme Court granted interim bail to Kejriwal by exercising extraordinary powers solely for the purpose of general elections and not on merits. He further submitted that there was no doubt as to the commission of a money laundering offence since cognizance had been taken by the concerned court and the cognizance order had not been challenged. He said that there is evidence that money was demanded by Kejriwal, which can be proved not only by statements recorded by the Enforcement Directorate officers, but also by the magistrate. The matter will now be heard tomorrow for completion of arguments and rejoinder. Stay tuned with us. The Bombay High Court today allowed release of the film Hamare, Baarah on 21st June this year after the makers agreed to make certain changes in the movie. The screening of this film, scheduled to release on 14th June, was suspended by the Supreme Court after it found the teaser to be offensive. The film is alleged to be derogatory towards the Islamic faith and married Muslim women in India. A vacation bench of the Supreme Court had passed the order halting its release until disposal on the merits of the case pending before the Bombay High Court. Today, Division Bench of the Bombay High Court, comprising Justices B.P. Kolawala and Firdosh Puniwala, passed the order in a writ petition seeking a ban on the film on the ground that it is derogatory to Islam and Muslims. The bench recorded the changes to be made in its order, to which the makers agreed. Also, the petitioner agreed not to raise any objection to the release of the film after the agreed upon changes are made to the movie. The makers have agreed to remove a dialogue and a Quranic verse and put two disclaimers of 12 seconds each in the film. They have also agreed to pay costs of 5 lakhs to a charity of the petitioner's choice. And the Central Board of Film Certification has agreed to rectify the film based on the changes by 20th June. The Allahabad High Court today dismissed a writ petition moved by a NEET aspirant after it was revealed that she submitted forged documents in her petition, alleging the NTA failed to declare her result. So the candidate here originally claimed that she had received a communication from the NTA in which she was told that her result would not be declared as her OMR sheet was found torn. She demanded a manual evaluation of her OMR sheet and an inquiry against the NTA. The court then directed the NTA to produce her original documents to verify her claims. Interestingly, when all original documents of the petitioner were produced before the court, it was revealed that all the documents filed with the petition were forged and fictitious. A bench of Justice Rajesh Singh Chauhan dismissed the petitioner's petition, deeming it a really sorry state of affairs that she filed the petition enclosing the forged documents. The National Testing Agency told the court that it was considering legal action against her, to which the court replied that it could not stop the authority from taking legal action against the petitioner. The Gujarat High Court has instructed the state government to establish a high-level committee comprising 3 senior officers to conduct a fact-finding inquiry into the Rajkot gaming zone fire incident, where the tragic fire last month killed at least 27 people, including 9 children. The inquiry aims to identify the culpability of Rajkot Municipal Corporation officers, including municipal commissioners who have served since the inception of the TRP gaming zone. A division bench consisting of Chief Justice Sunita Agarwal and Justice Pranav Trivedi emphasized that the investigation must be thorough and that any official found guilty of negligence should face consequences. From the submissions of the councils for the corporations, the court noted blatant inaction by the Rajkot Municipal Corporation authorities. The gaming zone in question was developed in June 2021, and the owners applied for regularization of the constructions under Gujarat Regularization of Unauthorized Development Act 3 years later. The construction consisted of a fabricated steel frame structure with steel patra boundaries. The corporation claimed that the permission was granted by the city police. Coming to an update on the anti-religion conversion laws matter. A petition was filed by a BJP member in 2022 seeking directions to union and states to take stringent steps to control fraudulent religious conversion and religious conversion by intimidation, threatening, luring through gifts and monetary benefits. Along with this petition, the court has tagged other PILs which have been filed challenging the laws passed by the states of Uttar Pradesh, Madhya Pradesh, Haryana, Gujarat, etc. regarding religious conversions. In November 2022, while considering the petition, a bench comprising Justices M.R. Shah and Hima Kohli observed that forceful religious conversions, if true, were a serious issue which could affect the security of the nation and had sought the response of the centre. The court also sought the responses of the states back then. The new update in this regard is that the state of Rajasthan has informed the Supreme Court that it is in the process of making an anti-conversion law. In an affidavit filed in response to the PIL, the state submitted that it does not have any specific legislation dealing with religious conversions. However, the state submitted that it is in the process of bringing its own legislation and till such time will strictly abide by the law on the subject and guidelines issued by the Supreme Court. Also, let me tell you, recently, while hearing another matter, a Supreme Court bench had orally remarked that some parts of the anti-conversion law passed by the state of Uttar Pradesh appeared to be violative of Article 25 of the Constitution guaranteeing religious freedom. And now let me tell you that the Supreme Court is organizing a special Lok Adalat from 29th July to 3rd August to facilitate amicable settlements of suitable pending cases. The special Lok Adalat is being organized in the 75th year of the establishment of the Supreme Court. The court said that organizing the Lok Adalat is pursuant to the commitment to accessible and efficient justice delivery for all sections of the society. Cases having elements of settlement, including cases relating to matrimony and property disputes, motor accident claims, land acquisition, compensation, service and labour, which are pending before the Supreme Court, would be taken up to facilitate speedy disposal. A petition has been moved before the Kerala High Court against the new academic calendar 2024-25, as per which working days in aided and government schools have been enhanced from 205 to 220. The plea has been moved by the Kerala Pradesh School Teachers Association, a recognized association of teachers of various government and aided schools. The plea states that the Director of General Education had passed the order enhancing the number of working days without hearing the affected parties like parents or teachers. It also states that it has been done without passing a formal order by the state government or the director. The plea further states that now all Saturdays other than second Saturdays and Saturdays falling within vacations have been notified as working days. The plea states that students have to attend extracurricular activities like NCC, student police cadres on Saturdays that grant them grace marks. It is also stated that students prepare for various scholarship exams on Saturdays, and thus the academic calendar has been issued without proper application of mind and without considering the scheme of Central Act in Right of Children to Free and Compulsory Education Act. The matter will be heard by Justice Ziad Rahman A tomorrow. Stay tuned. And lastly, the Bombay High Court has directed the Principal District Judge Thane to conduct an inquiry into functioning of a juvenile court in Bhiwandi, Mumbai, after a clerk allegedly refused to accept a charge sheet in a case despite High Court's orders. A division bench of Justice A.S. Gadkari and Neela Gokhale was dealing with an application filed by a juvenile accused seeking quashing of the FIR. The issue arose from an order of December 2023 where the investigating agency was permitted by the court to file a charge sheet upon completing the investigation. The investigating officer attempted to file the charge sheet at the juvenile court, but the clerk refused to accept it because the juvenile in conflict with the law was not present. The court strongly condemned the clerk's conduct, noting that it amounted to interference in the administration of criminal justice. The court directed the inquiry to be completed within 1 week of receiving the order and directed the Principal District Judge Thane to submit the report by 26th June. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.